And
call the meeting to order. And would you like to do the flags? Yes. I see we have Martha online, so is Dana, or do I have to do a roll call?
She was running to Willow Creek.
Okay,
So I thought she'd be back. Yeah, if you want to go ahead.
Okay, so I'll do roll call. Tom.
Norman, Little Creek.
Very Muddy Salyer. Laura Lee George. And Martha.
Yeah, Martha McLaughlin, Orleans.
Okay, we have Debbie Myers, absent, and Kadusha Polo, absent.
I'm here.
Oh, hi. Hi, Kadusha. Okay, we do have 6, so that is a quorum. So, okay, adoption of the agenda at a regularly, I don't think I need to read all of this.
I move we adopt the agenda as presented.
Tom moves, we adopt the agenda. Is there a second? 30 seconds. Moved and seconded. Roll call, Kadusha. To approve the agenda.
You raised your hand.
Raised your hand, okay. Martha,
Aye.
Burley, yes. Carrie? Yes. Rob?
Yes.
Tom?
Yes.
Okay, the agenda is adopted. Did we have any public comments?
Sorry,
on
who
agenda?
seconded on the? Tom and Kelly third. Okay, just who seconded on it?
Moved and Carrie
Very
seconded.
seconded, thank you.
Was there any public comments on agenda items?
I didn't see.
Nothing came in, okay. Board study session of the Brown Act, collective bargaining, discrimination complaint process, and governance trainings provided by Carrie McNally, partner of Adam Silva and McNally LLP. Carrie.
All right. It's good to hear everyone in presenter mode here. Everybody's really, really tiny, so I can't really make anyone's faces out, but it's good to hear you and see you as well. And I have invited Lori Kammerer, an associate in my firm, to join me tonight as a presenter because it's really a really long time to talk and listen to one person talk. So we thought we'd break it up with 2 of us and thought that it would bring a couple of different perspectives for you all to hear from as we work through this. The first topic that we're actually going to do 2 different presentations, taking a break between them. The first one is a larger presentation that we've called The Crossroads of Good Governance. And in this presentation / training tonight, we thought that we would cover a few critical topics. One is sort of the board's role in the overall system of the school district. We also thought that we would provide an overview of the Brown Act. There's going to be a lot in the Brown Act that we don't cover, but we thought that we would talk about the most relevant and the most common things that come up for board members related to the Brown Act. And then we're going to talk about the complaint procedures that the district has related. We're going to give an overview of all of them. More specifically, we're going to talk about them as it relates to harassment, discrimination, retaliation, and the board's role in those complaint procedures, and then how that all circles back to the board's role in the school district. And so during this time, if you have questions, don't hesitate to ask. A couple of just sort of thoughts, make sure, one, to speak up and let us know who's talking, because that's kind of hard from where we're sitting. So that would be appreciated. And then also, our firm represents the district. And so, we're not going to use this opportunity to give specific legal advice to the district, because it is not a confidential setting. This is a training, a workshop to give you all an overview. And then if there are specific questions, we can certainly address those through staff. But I just want to kind of throw that out there so that you kind of know what to expect if you do ask questions. All right, so as we get started here, the first thing we're going to talk about is the board's role in the district. And sometimes, this causes a little bit of confusion. Sometimes it is challenging as you serve as a board member to know, like, what am I really supposed to be doing? When certain things come up, what am I supposed to be keeping in mind as my responsibility so that I don't, people mess up. People tell us that all the time. I just don't want to mess up. And so, we'll talk about that. And then the other is to ensure that you're able to actively participate in all of your activities as a board member. It's really important that every board member have a clear understanding of their roles and responsibilities. So I kind of see the board's role sort of like our nation's governance system, right? The board has some functions that fall into all of areas of governance, or the branches of government that our country has for it: the legislative, the executive, and judicial. Each distinct though, and it's important for board members to remember their responsibilities in each of them. Some of the branches, the board has more responsibilities, and in others, obviously less. But as you think about it in this way, you will be able to kind of anticipate what it is that you should do when, say, approached by a community member with a concern. If you think about how is that going to come back to the board potentially, and what role in governance will I be sitting in, such that I can make an informed decision when the community member approaches me. So we'll talk first about the board's legislative capacity. And here's really where the bulk of the board's responsibilities lie. The board's responsible for setting the direction of the district, setting the district's goals on an annual basis, on a more short-term basis sometimes, and sometimes on a longer-term basis, right? 3 years out. We talk about the financial responsibilities that the board has, and setting direction. We have to think about the 3-year plan for the district. So this goal setting and the policies that the board enacts to effectuate those goals, that is really where the board's meat and potatoes are, right? This is where the crux of your responsibilities are. And it is like the legislature, right? They're the ones that come up with the policies, the laws, the expectations for how the government and the people are going to act. And that's really your responsibility as the legislative, in your legislative capacity. Then we have the board does have an executive capacity. This is probably the least significant role. And here, really there is an element of making sure that things are carried out, those goals and those policies are followed, but the person and the people who are boots on the ground responsible for that are the superintendent and staff. And so the board's role in that is to support the superintendent and the staff as they begin to implement the board's direction. Sometimes that can take the form of, just being that person who the superintendent can talk to. Sometimes that support means taking additional legislative action to ensure that the programs and the goals that the district wants to see carried out have the support to make it happen, right? If the district wanted to create some after school or preschool program, but then didn't provide for the staffing in that program, obviously that would be a problem. And so there's the support that is provided, but it is sometimes created and effectuated through its legislative capacity as well. In addition to the legislative and the executive capacity, the board also has a judicial capacity. And here is where the board will sometimes be the final fact finder or determiner of complaints or disciplinary issues that come before the district and then ultimately to the board. And we're going to talk about this in detail later, but often and in many cases, the district has complaint procedures where after the complainant has gone through the process with his or her immediate supervisor or the principal at a site, it then appeals to the district office and then to the superintendent and then ultimately to the board. And you then are the ones that are looking at the investigation. You're the ones that are determining, was there a factual basis for the determination that was made by staff, whether that be in the complaint or in the discipline arena. And so you, again, here you see where you really do act as like, sort of like a judge on an appeals court where you're determining, was there evidence or facts to support the district administrator's decisions? So there's all three capacities, and it's really important to remember that they are separate and distinct responsibilities, because if you if a board member oversteps in one of the areas, there are some potential consequences that can happen. And some of those consequences are the board member and other board members, members of the public, employees, they can be confused. Well, I thought that I was supposed to, when I had a concern, I thought that I was supposed to go to my site principal, but my colleague down the hall here, she went directly to the board member and she got immediate relief. So I'm confused. Should I go through the complaint process or should I just go to my individual trustee? So there can be some confusion. Also, that piggybacks on the next one, inequity. Someone can feel as though they're being treated unequal to their counterparts, or being favored or not favored in comparison to others. And that obviously doesn't sit well with staff or parents when they believe that someone else is getting more or better treatment than they are. The other inequity that can be created if the board kind of oversteps in one of its roles is it can be an inequity of information or power amongst the board members. For instance, if there is a community member or a parent or a staff member that's upset with something happening on a school campus, and they come directly to the board member and they say, so-and-so has really upset me, this is what they're doing. If the board member takes it upon themselves to explore in detail what that is, they are going to gather information and potentially come to conclusions that are different than other members of the board, and maybe even different than other members of staff, because a full investigation isn't done. You're hearing that information just directly from the complainant, but not getting the full picture from everyone else. And then when it being the complaint ultimately comes to the board for review in the complaint procedure, it's difficult to sometimes overcome. Well, wait a second, I heard X, Y, and Z from this parent or community member. Why is it now that that's not what we're finding as the case? And so the inequity that could arise is a problem. And then what could happen there is that there could be a actual conflict of interest, or at least a perceived conflict of interest, that someone is biased in favor of or against one of the parties in the complaint process, which then could lead to a necessary abstention from participating in that review of that complaint. So, there are, as outlined here, there are consequences if we, allow ourselves as board members to stray from those areas, those 3 different roles, and overlap them, and sometimes step more deeply into the executive role than we should, right? The place where a board member wants to spend the majority of their time and efforts is in that legislative role, occasionally in the judicial role, and then sometimes in the executive. But again, it's really through the policy making and the support that a board member is in the executive role. Before we move to the Brown Act element of this, I do want to kind of pause and see if there are any questions that you might have on this topic before we dive into the next topic. All right, well, hearing none, I will ask Lori. She's going to talk a little bit about the Brown Act.
Hi, everyone. Good evening. I'm Lori Kammerer, and it's nice to, like Carrie said, not necessarily see you, but to be before you here this evening. So I'm going to talk about the Brown Act a little bit. And as a quick and brief introduction, the Brown Act is intended to provide public access to meetings of California state, local governmental agencies. And the Brown Acts can be found in Government Code sections 54950 through 54963, if you have any interest in looking that up. And kind of moving forward, to achieve the Brown Act's objectives, agencies that are subject to its requirements must generally provide, among other things, public notice of meetings and public access to their meetings. So that begs the question, it may sound pretty simple, but what is a meeting under the Brown Act? Well, the Brown Act simply defines a meeting as a majority of members gathered at the same time to hear, discuss, or to deliberate on any item within the subject matter jurisdiction of the governing board. And you'll see that the definition of meetings, I know it's very simple and straightforward here, but it can encompass more than maybe the meeting that we're seeing here today, more than just a regular meeting. It can encompass a little bit more. But first, let's talk, before we talk about what is a meeting, what are the different types of meetings, let's talk for a moment about what is not a meeting. What a meeting is not under the Brown Act. A meeting is not individual contacts or conversations between, say, a member of a board or the agency and another person. A meeting is not a public educational conference. A meeting is not another agency's meeting, say another governing board of a completely different agency. Members attending that's not a meeting for their purposes. A meeting is also not a community meeting, it's not a social gathering, it's not a ceremonial event. So those are some things that may be considered gatherings and may seem official or not, but they're not considered meetings underneath the Brown Act. So we know what's not a meeting, but what is a meeting and what are some different types of meetings? First, we have regular meetings. That's pretty easy to identify. Regular meetings are those occurring at dates, times, and specific locations set by resolution or ordinance or other formal action by the agency. And regular meetings, you may know this, but they're subject to 72-hour agenda posting requirements. So those are your regular meetings, and you've probably attended a few by now. Special meetings, those are a little different. Special meetings are meetings called by the presiding officer or a majority of the agency, the legislative body, to discuss only discrete items on the agenda. And those are subject to a little bit of a shorter public notice requirement, and that is a 24-hour posting requirement. So those are a little less frequent and a little more rare than a regular meeting. So what about an emergency meeting? Well, those are especially rare. Emergency meetings, they're rare. They're limited to scenarios where prompt action by the board is required and needed due to actual or potentially imminent or threatened disruption to public facilities. And those are held on very short notice, potentially, sometimes as short as 1 hour of notice. So those are going to be very rare. Perhaps occurring in the event of a pandemic, which a couple years ago we probably thought would never happen, but now we have that context. So serial meetings. Well, serial meetings, these are a little special and they're a little unusual. And again, like I said before, these may fall under that, oh, we didn't realize that meetings encompass this. Well, that's when we're going to talk about serial meetings. And you may be kind of surprised about what this definition encompasses. So serial meetings are communications occurring outside of formal meetings, each of which individually involves less than a quorum, but collectively, when taken all together, encompasses a majority. And it's easy to fall into, unintentionally, it's easy to fall into this serial meeting situation, and I'll kind of explain how that can happen. So again, serial meetings are going to be outside of the formal meeting setting. They will occur over potentially multiple communications that are among board members on a subject that's within the board's subject matter jurisdiction. They can start potentially between just 2 board members. But if the communication continues, if it spreads, if the discussion then goes and adds more board members in and it reaches a majority, which for this board is 4 members, then it can constitute a serial meeting. So serial meetings can be direct or indirect. They can be face-to-face, live, in person, and sometimes more commonly, and this is where you can get trapped, via technology. So over email, text even, phone calls. That's a way where serial meetings happen, and unintentionally so. Serial meetings can be used to deliberate on items or vote on items. As kind of a final thought on serial meetings and why we find it so important to identify and define what they are, how they happen, and how they can unintentionally happen. It's important that agencies are really mindful about these kinds of communications, especially as they occur electronically. So especially as they occur over your email and your text, because those electronic records, they're discoverable. So they can be discoverable by subpoena or by a Public Records Act request by a member of the public. So that can happen even if they're on your personal phone or your personal email. they're still discoverable. And so that's why we find it so important to identify what those are and how they happen.
And I'll just, I guess, reiterate one of the things here is that the biggest concern that comes up with these is the phone calls, the text messages, and the email. And while social gatherings are not meetings, and you certainly can socialize with your fellow board members, it's when those social gatherings or those social conversations via telephone, text, or email turn into a discussion about something that happened at the last board meeting or an issue that we know that is now presented to the board. And when you are just talking with one of your fellow board members, that's generally not going to be a problem. The challenge is that then the two of you who are talking don't know if one or the other of you is going to then go have a conversation with a third person. And then those two people don't know if one of them is going to go have a conversation with now a fourth person. And again, it can be a verbal conversation, a text, or an email. And it's not even necessarily to determine whether or not someone's going to vote a particular way. It's just discussing an item that's within the jurisdiction of the board. And so again, it could just be, last time we talked about at our board meeting, a potential reorganization or a potential layoff, and that really concerns me. And I'm worried about X, Y, and Z happening if we do a layoff. And then the person responds, I'm worried about that as well, and I'm also worried about something else. And now we've started down that potential path of having a serial board meeting without even really realizing it. And so it's really important to think about that and refrain from engaging in those conversations outside of a formal board meeting. Now, something that comes up a lot is, well, what about this idea of polling the board, right? And I know that it's come up as an issue here, and there is a distinction, and it's specifically provided for in the Brown Act, where the superintendent or staff, because they are not board members, can't have, sorry, that I think came out wrong. They can have conversations with individual members of the board. They could have a conversation with every member of the board to provide answers to questions, provide information, and gather some of that information with respect to, it's typically just, we recommend, it's typically just minor things like, do we need to have a special meeting? What happened with respect to X? But the thing is that, and the most important thing in this is that the superintendent or the staff member having this conversation with each board member cannot communicate the comments or the positions or the opinions of other board members to the member that he or she is talking to. And so that's the critical distinction. There can't be any sharing of other people's positions, because if there is that sharing of the position, then we come into a place where the superintendent or the staff member is really just a straw man for a serial board meeting. And that's not allowed under the Brown Act. So there are some circumstances where this is allowed. It's just really important to be careful that the positions of others are not shared.
Carrie,
I thought I saw somebody's hand waving.
this is Jen. Can you hear me?
I can.
Okay. I have a question about meeting. So can I ask you now about a special meeting? So or it could be for Lori. I had a meeting with the Valley Tribes the chair, and he asked if our board could meet with the tribal council. So presumably we will all, the entire board will attend, or at least a quorum will attend it. And so I was, of course, thinking it would be agendized, but what Lori had said was the meeting of another agency is not a board meeting, but they're specifically inviting us. We wouldn't have necessarily things where we would be taking action, but I think the goal is to discuss the goals of the tribe that complement the goals of the school district and just have that conversation. So what would you recommend in terms of this next part with agendizing? Is that a meeting if we are guests at the tribal council's meeting?
So there are provisions that allow for joint meetings, but so we would want to talk about a little bit more about what the overarching goal of that session is. Is it so that the school district's board can talk about and discuss and deliberate over things kind of jointly with the tribal board? And then ultimately, even if no decisions are made, we're still talking, discussing and deliberating things that are within our jurisdiction.
Yes.
Because if that is the case, then we would need to make and do an agenda. The thing that Lori was talking about with attending other agencies' meetings, a majority of the board could go and sit in on somebody else's meeting and do nothing, just sit and listen. And that would be different than what I think you're describing, where there would be this active conversation and discussion and deliberation amongst not just the district's board, but also the tribe's board. And so that we would want to, we'd want to nail down some of the details on what's intended there, and then come up with the appropriate agenda items.
Thanks. Yeah, it is the latter. It is not just to sit and observe the tribal council's meeting. It really is they're asking for the board to show up and engage in discussions, topics yet to be determined.
Okay. So then, we can talk about what we'd want to have on that agenda. We'd want to make sure we were complying with the location. There's rules related to where you have the board meeting. Obviously, this would be a special meeting, that sort of thing. So we would just need to talk more about all of that to make sure that we've got it all appropriately agendized and posted for both entities.
You have a couple more hands. I don't know if you can see us.
I would be comfortable going to a tribal board meeting and listening. I would not be comfortable going to a tribal board and having discussion of our business. This is where we do that.
Well, and
as a board member from Willow Creek, I would not be comfortable going to another location and having a board meeting other than our school district. It doesn't seem right to me. I would be glad to go to a Hoopa tribal meeting and listen to their concerns. That makes sense. Just like I would be glad to go to other areas of listen to people's concerns. But it doesn't make sense that we would go to another location and conduct our business.
Right.
That we would do that at various schools around our district makes sense to me.
so I do want to caution you about making sure we stay on topic with our agenda, because what was, and this will piggyback into what another later topic about the Brown Act is that I think it is a healthy conversation to have about whether or not the board wants to participate in this joint meeting. But that's something that needs to be that conversation and that dialogue is something that needs to be posted on an agenda so that the public also has an opportunity to participate in that conversation and hear that conversation, right? What we don't want to have is a conversation about whether or not to participate in this joint meeting and leave the public out, right? I think that it is 100% an appropriate discussion to have. We just want to make sure that we get it appropriately on an agenda for a later meeting. So I don't want to offend, and I don't mean to offend it in cutting that conversation short. I just think we need to make sure that we get it on an agenda.
Understood.
The other thing that I think is that, there are opportunities for these meetings to be joint meetings, and they can be, because they would be a special meeting, it's for a specific topic, very limited topic. They don't have to be your regular, and they most likely would not be your regular board meeting for the month or one of your two for the month. These would be a special meeting specifically designated to be like a study session with the tribe, right? Or something to that effect. And so the other business of the district that it sounds like there's some concern over would not be the topic of of that meeting. It's going to be this very specific designated topic that relates only to the matters that are shared by the tribe and the district. So that's possible to devise a special session or a special meeting agenda that's very, very narrowly tailored. Just like this one, it's very narrowly tailored just for the purposes of this presentation, or this and the next presentation.
Carrie?
Yeah.
I have a question on polling the board.
Okay.
Now, superintendent or staff only. What about, I have a situation where I had a board member after a meeting that we had taken action on, interpret what we had acted on totally different than what my interpretation was. And so is it possible then to call another board member to see what their interpretation of the action taken was? Or is that polling the board? This is after the fact.
Right. So I don't want to get into legal advice, right? And I know that you're talking very specifically about a specific incident that actually occurred. So the issue that I would caution, a couple of things that I would caution you on. One is you're a board member, right? And by having the conversation with initially the first member who had a different recollection, and then going to a second member, you're now at 3 members, and you are right up against that majority. And you don't know when you approach that second member if he or she has already talked to someone else, right? And so by having that conversation as a board member, you have entered, by having that second conversation, you're entering into the realm of very real possibility that there's a serial board meeting going on. And so I think that even though the action had already been taken, this was still for the purposes of discussing matters that were within the jurisdiction of the board. And if you did that polling, there would be some very possible, potentially even probable problems with running right up against the serial meeting. And so I guess maybe another way to say it is that even though the action had already been taken, if there was a disagreement about that, it very much could then still be a live issue for debate, right? And there'd be a really fine line, potentially keeping you away from a serial meeting. So I think if in those types of situations, it's best to have the superintendent so that we're not do that communication, so that we're not running up against that potential.
Thank you.
All right. Any other questions there? Sorry, I'm squinting to see if I can see anyone. Okay, not seeing any. I'll move on to this agenda topic. And on this agenda topic, really what I want to identify here is that there are, some big topics that I think board members need to be aware of. One is the posting requirements, the open session, section of the agenda that we have, the closed session section of the agenda that we have, and then also the issue of public comment. The posting requirements. Lori already talked about the regular, the special, and the emergency meeting and the time in which they need to be posted. So I'm not going to reiterate that. But what I do want to identify is that for open session, when you post the agenda needs to identify in a short and concise manner the topic that's going to be discussed or deliberated or discussed, deliberated, or voted on. And it needs to be sufficiently descriptive to put the public on notice that about what's going to be discussed or deliberated or voted on. One place where I saw this come up as an issue for a district was in a situation like this, where we had a posting that it just said generically board workshop, I think is all that it said. And that was a concern because it didn't tell anything about what the workshop was going to be about. And so we want to give a little bit more information than that, just so that the public knows, okay, well, they're going to be talking about discrimination, retaliation, Brown Act, governance, collective bargaining, whatever it is, right? And so the public knows. The closed session agenda items, though, are a much more limited beast, if you will. And that's because closed session is confidential, and we'll talk about these in a moment in more detail. But it's really important to recognize that your closed session agenda items that are actually posted don't have to have the specific details that your open session items have. And that's totally fine, completely acceptable, and in many cases necessary, because some topics that are appropriate for closed session, the general public doesn't have a right or really any business knowing about, because they are things related to students or staff or confidential communications between the board and legal counsel, and those are for the board's ears only and the staff that they invite in. So, I've seen board members, not necessarily here, but I've seen board members in other districts become very concerned that the closed session items are stock type statements that don't give a lot of detail. And it's sometimes hard to convince them that that's okay. The law allows for that. But the law, on the flip side, wants to see a little bit more detail and description on the open session items. Now, a word about public comment, right? We all know that the district has to have an opportunity for the public to provide comment on any item that is on the agenda. In a regular meeting, the members of the public also have a right to comment on any topic that's within the jurisdiction of the board. In a special meeting, they only have a right to comment on items that are in or on the agenda. It's not the same carte blanche opportunity. But nevertheless, at every meeting, they have the right to be heard. Now, the caveat to that, and something that's really important to know, is that the public's opportunity to comment during a board meeting does not convert this meeting into a town hall meeting. When the public is commenting, it is simply their opportunity to share with you as board members their thoughts, feelings, observations on that topic. It's not a dialogue. And I think that is sometimes, especially for really new board members, to something that's hard to grapple with, right? Because this person is standing at the podium, pouring their heart out, really expressing something that they feel strongly about, and to not engage with them just seems odd at best and wrong at times. But it's not designed to be a dialogue. But that doesn't mean that there can't be a short response. And typically what I see and what I think is best practice is that the response not come immediately after the comment, but rather come in the board member's own personal opportunity for comment. And then at that point, if someone's public comments really caught your attention or something that you really want to express your opinion on, you can go back and you can say, with respect to this comment, I just want you to let you know that I hear you, and we're going to ask staff to look into that, or something like that. But I don't think that it's appropriate to then engage with them if you disagree with their position, right? It's your short opportunity to just provide a response. You can refer the matter to staff for inquiry, or ask them to go to staff and talk to them about their concern. That's totally fine. But what we don't want to have happen is a back and forth dialogue, because then it takes away from other people's opportunity to give their opinions and have the board hear their thoughts. And it also can be disruptive at times, and we don't want to get the board off track and lose sight of the fact that we have the rest of the agenda to get through, because typically, and I think here as well, at least as it did tonight, public comment happens first. And if we get too off track, or if we get a disruption, that's going to impact the way that the rest of the meeting operates. And so I fully encourage the board to have the public comment opportunity. I encourage you to listen intently to the members of the public, but I don't think that it's in the best interest of the board meetings to engage in discourse about the concerns or problems that are being raised sitting on the podium there, or sitting at the podium there. Okay, so then we'll get briefly into closed session. As I mentioned, closed session, one of the biggest things to keep in mind with respect to closed session is that it is confidential, and that it is very clear that regardless of whether or not an attorney is sitting in closed session, the information, the conversations, the discussions that happen in closed session are confidential and cannot be disclosed to anyone outside of that closed session room. And so sometimes I am almost floored by the action of board members who know this and have told me, I understand my responsibility to keep this closed session conversation confidential. And then they walk out of closed session and they talk about it with someone. In fact, just the other day, I had a closed session meeting with a school district, and as soon as we were done and the board decided that they wanted an investigation done, as soon as we were done, a board member walked out of closed session and contacted someone who they knew was going to be part of this investigation and said, hey, an attorney is going to be contacting you to discuss an investigation that the board has authorized to have happen. I don't want you to worry. I just want you to have a heads up that they're going to be reaching out to you. I mean, when the superintendent called me and said that this had just happened, I was at a loss for words, because this is a long-standing, very experienced board member who knows better. But sometimes things just get the better of people, and they don't use their best judgment. And so I don't think that it can be stated enough that it's just important to remember that this is confidential. Ultimately that principal would know that I would be reaching out to him to interview him for an investigation. And ultimately I would be telling him that I don't think he has anything to worry about and that he just needs to fully cooperate. But the board member took that into her own hands. So, okay, as I mentioned, there are limited purposes for closed session, and these closed session items need only be described in a limited manner. Probably the most common closed session items are negotiations with collective bargaining units, matters related to employment, pending and threatened litigation, so that there can be a conference with legal counsel, and then updates related to real estate negotiations if there are land purchases or leases that are going on that need direction given to the negotiators. Now, a couple of thoughts on all of these. What the Brown Act does, what the legislature has graciously done, is they have told us that there are these topics that you can go into closed session and talk about, and then they've given us what they call safe harbor language, such that if a public agency is in closed session for the purposes of talking about one of the legitimate closed session items, if they put it on their agenda in the manner stated in the Brown Act, there's not going to be an issue with the way that they've listed it on the agenda. Now, that doesn't mean that maybe they're not in there to actually talk about that, which would be a problem. But it means that the listing on the agenda is all good and well, and that won't be a violation of the Brown Act. But there are times when things don't quite fit into those safe harbor language provisions, and we still can go in and talk about them in closed session. For instance, one thing that often comes up is complaint proceedings related to employees, whether they are the complainant or they are complaining about other employees, or the community is complaining about an employee, and we're going to be discussing whether or not those things happened, and it comes to the board for that review. That's not exactly what's contemplated in one of the safe harbor language provisions that's commonly used, which is public employment, discipline, dismissal, release. That, if somebody's just upset that the teacher yells and screams in class, it may not fit under discipline, dismissal, and release because we're not maybe going to do one of those things. But the Brown Act says that we can go into closed session and talk about complaints that are raised against employees. And so sometimes we have to come up with a little bit more creative language to put on the agenda. And that's totally fine. It's just not one of those safe harbor provisions that are specifically included in the Brown Act. Okay, another issue that I know has come up, and sorry, I paused because I thought I saw a hand, but maybe not. Another issue that I know has come up is the distinction between, that relates to negotiations, and the distinction between what's supposed to happen in closed session and what can happen in open session. Now, open session, I believe that Jennifer has on the agenda, or at least has kind of a standing item when she's giving updates on the state of the district, is to give a short synopsis of how things are going in negotiations with the union. That's permissible so long as what Jen is disclosing has been exchanged at the bargaining table, and so long as what she is describing is factual and accurate. And, but that is very different than what is discussed in closed session. In closed session, that's the opportunity for Jen and the board to discuss very frankly about where things are going, where things have been, and what the board's authority is for her and direction is for her when she goes into negotiations with the union. Those things are appropriate for closed session, and they are most certainly not appropriate for open session, because that's where, you know, Jen has the opportunity to say to you something like, you know, the union has asked for 20% increase, and for the board to say, you know what, really, you're gonna have to, you know, you got your work cut out for you, because we can only give 1%. And it's your opportunity to strategize with her how we get to an agreement. And so you wouldn't be having those negotiations or those discussions in open session, because those are confidential between you and the superintendent. The other thing that's really important to remember is these employment issues. Actions that are readily knowable, for lack of a better word, but that are you know, information that's readily available. Those things can happen in open session. So related to personnel, but things that relate to their appointment, to employees' appointment, employment, discipline, complaints, those things are closed session matters only. One topic that sometimes can show the distinction here is if the district goes to do a layoff, the district is required by law to adopt a layoff resolution in open session. That's because those positions, and it's just about positions, those positions will be eliminated. Now, granted, employees are attached to those for sure, but the employees that are attached to them are not what should be discussed in open session. Rather, it's just the position that is going to be eliminated. If there are employment issues with the people attached to those layoffs, those conversations should be held in closed session. Now, I will say that layoffs should not be used to deal with disciplinary or employment issues, but sometimes in a layoff scenario where we're then talking about moving people around and what's going to be in the best interest of the district once people land after a layoff, those employment issues are relevant, and those conversations should be held in closed session, not in open, because that's someone's private employment business, not for the world, if you will, to know. Okay. The last topic that I wanted to just mention here with respect to closed session is sometimes I have board members say to me, or say, or ask me, I guess, how, you know, Carrie, you've talked about the importance that the board, you know, keep its head on straight and not meddle in the details about issues, and because sometimes we can be called upon to make a final decision on a disciplinary matter. And so how come then the superintendent or the assistant superintendent of HR can come in and give me information about this employee who's having employment issues? How does that not create a problem for me when I then later am going to sit as the final determiner of whether or not something has gone, you know, is worthy of discipline? Here's my my response to that. So a superintendent or an assistant superintendent of HR can certainly give boards in closed session an update on employee discipline. So if an employee has engaged in bad behavior, the superintendent can certainly say to the board in closed session, hey, today, this, employee, it was alleged that he or she, I'm just going to go out extreme here, he or she hit a kid on campus during recess. That would be something that would be 100% appropriate for the superintendent to let the board know during closed session that it happened. The follow-up statement should be the district, I'm having staff investigate. We're going to work with legal counsel to decide what the appropriate next step would be. It's appropriate to keep the board informed and apprised of such things because heaven forbid you go home and 2 days later you hear on the street that this happened. I don't imagine that very many board members are going to be real pleased to have a community member raise this to them for the first time and they didn't hear it first from staff, especially if staff knew. And so it's appropriate for the, a very short overview of what the allegations were or what the lower level disciplinary determination was. That can certainly be shared with the board. Where it potentially gets can go awry is if too many details too early on are shared with the board. When the superintendent or the assistant superintendent doesn't know all of the facts yet, but they are shared with the board as fact, that can be a problem. But if an allegation is raised and some low-level discipline like a letter of concern or a summary of conference is issued on something that's a hot topic, it's definitely appropriate and fine to share that information with the entire board. The other reason that it kind of makes it okay is because all of the board is given the same information. It's not as if just one or two board members are given the information about the incident or the discipline that's given. So I know that that's a frequent question and concern for board members, so I wanted to address that with you before we leave this topic of closed session. And the final thing, just because, as I said, I don't think we can say it enough, closed sessions are confidential. Those are two, that's a really important bookend that I just want to reiterate. Are there any questions about the Brown Act in general before we move on to the next topic that we'll address, which are the complaint procedures and how the board's role as like in its judicial capacity can come into play?
Good.
Okay, Lori, go ahead.
Okay, great, thank you. So I will talk a little bit about the board's role in complaint procedures. And you will probably remember at the beginning of our presentation, we talked about the board's role. And we talked about sort of these three branches that we all know pretty well: legislative, executive, and judicial. Well, your role is very important, and the definition of your role is very important in complaint procedures because there, the board is acting in a quasi-judicial role. And in that role, and just like any judge anywhere presiding over a civil trial or a criminal trial, whether it's the Supreme Courts or a trial courts, they must be unbiased. Here, the board members can't do anything to compromise their neutrality or their unbiased role when it comes to complaint procedures and that judicial role. So there are a couple of sources for complaint procedures. First and foremost and most robustly in the district's board policies, which we'll view a kind of an outline of each board policy, what it encompasses, and the board's role in that procedure, if any. So they'll be on board policies and also potentially by employee collective bargaining agreements. For example, and this is just one example, but the district's agreement with the Teachers Association, KTTA, references a complaint procedure ending ultimately in appeal to the board. So we'll look at those as well. But let's start with board policies.
So Laura, I just want to interject one thing really quickly. You know, what's sort of interesting about complaint procedures is that you see here the board's role is both the legislative functions in that capacity, because it's the board that creates these policies. It's the one that sets board policy that says, you know, this is how we want to process these complaints and concerns by community members, parents, employees. And then ultimately, as you know, Lori's going to talk about, we're also going to see you sitting in the judicial capacity. And so what you will see that's missing there is the executive, and the executive function really needs to be left to the superintendent and staff so that you can be preserved as in the judicial function. All right, go ahead, sorry.
Yeah, that's fine. Thank you. Absolutely. So talking about complaint procedures that are found in the district's own board policies and administrative regulations, you will see there are several. And in fact, I believe I counted 10 in total. And all but 2 will end in ultimately, potentially, an appeal to the board. So I know this is a lot, and each topic is described, but really we can break these down into sort of 3 broad categories. One being discrimination type complaints, discrimination, harassment, any kind of unlawful conduct type complaints, student-based complaints, and then just sort of your general more employee relation, employment type complaints. So those are 3 pretty broad categories, and I'll run through which belongs in which category just to sort of help you familiarize what goes where. You can probably tell by the topic, but for employment, we have board policies 1312.1 and 4144. For students, complaint procedures, we have board policies 1312.2, 1312.4, 51, I believe it's 25, and 5144.1. And then finally, for discrimination, we have a handful of policies. And again, discrimination, it could be unlawful discrimination, harassment, retaliation. These are policies where somebody is alleging that because of their protected classification, you know, their race, their gender, disability, age, they have experienced some sort of adverse action. So those kinds of complaints get their own sort of categories of complaint procedures, and you'll see those outlined in board policies 1312.3 potentially, 4030, administrative regulation 4031, as well as board policy, and I believe it's just sexual harassment, that's 4119.11. And I pause at that particular board policy because I understand that the board recently, you know, while we're talking about complaint procedures, I understand the board recently just finished a sexual harassment training. And I wanted to take a moment to ask, does anyone have any questions on that training? And I don't believe I'm seeing any hands. Or hearing voices.
And the one that Lori is talking about is, I think that you guys were asked to complete the Keenan online board training related to sexual harassment and discrimination as a supervisor of the 2-hour doozy of a training. And since those are online and not live, we thought we'd give you the chance to ask any questions that you might have about that here as well.
It was 71 minutes.
Ah.
you can probably answer our questions.
Okay, well, great. Then no questions. We'll keep moving on.
Yeah, well, that's great to hear. And it's great that you completed that training. I know that is a long amount of time, but it's an important topic and important to get the training on it. So it's great that everybody seemed to understand and appreciate that training. So another source again for complaint procedures, I mentioned very briefly, but that would be the those that are identified in employee collective bargaining agreements, which potentially ends in appeal to the board. So we've got that with CSEA's agreements as well as the Teachers Association's agreements. So those are also two sources in which an issue, complaints, matter could come before the board in the board's quasi-judicial role. So a complaint procedure ends in an appeal to the board. What does that mean? What does it mean when something ends in an appeal to the board? And what's the board's role and what really happens? Well, usually the complaints will have been investigated and it will come before the board. It will come in typically closed session. I mean, these are we just talked about confidential matters. It'll come in a personnel type action or any other confidential matter, and it will be in closed session. The board will get to listen and hear facts and evidence gathered by the district, potentially an outside investigator. And ultimately, the board will be the entity that makes a decision and reports out that decision. So that's why, I mean, being the ultimate say at the end of a complaint procedure, that's why it's so critical for the board to remain unbiased before and obviously during a hearing that is before the board on an appeal ultimately stemming from a complaint procedure. This means refraining from doing, and we talked about this a little bit, but I do want to emphasize, this means refraining from doing your own independent investigation. It's possible a matter comes before you in closed session, you'll kind of know about it beforehand, you'll have heard about it. Refrain from trying to get to the bottom of things on your own, because that's a separate role and that's not your role. It's not going to be your role if you are the judicial body. So it's important not to do that. Sometimes a complainant or even a respondent, the person who is being complained about, they will seek out a sympathetic ear. They may contact an individual board member, the board as a whole, and say, you know, hey, this has been going on, I made a complaint, this is everything that happens, and they'll want to talk about it. It's important to remember your role if that happens and kind of refrain from engaging too much or letting yourself ultimately become biased. Because if you go into that hearing with your mind made up, then you haven't really fulfilled your judicial role. And so we don't want you to get into a situation where you ultimately have to, like a judge would, recuse yourself from the closed session hearing, or to have to abstain from voting, because then you're not fulfilling your purpose and your role there on the board. And so that's really why understanding, and that's why we started with what are the 3 different roles, but it's so important in this specific area, and it really is, it's something to remember whenever there's a closed session hearing on a complaint procedure that's ultimately ending in an appeal before the board.
So one thing that I'll add here about an appeal hearing is that typically what happens when there is a complaint, and under all of those board policies that that we had on that slide a few minutes back, is that a complainant raises a concern. And at the very beginning of the process, once there's a formal complaint, and at times even when there's an informal complaint that is like about discrimination or sexual harassment or something, the district will initiate an investigation. That investigation is either conducted by staff or by a third party investigator. and those findings are reached. Sometimes those findings are simply that there's not evidence to support the allegation. It's not that the investigator believes that something did not happen. It's just that the evidence does not show that it did. What then happens is the complainant and the respondent are both informed of the results of the investigation. And in all but 2 of those procedures, the complainant is informed that they have the right to appeal the decision to the board. And then what happens is that at times the board has the right to decide whether or not they want to hear the complaint and make a decision, or if they just want to affirm the decision from the level below. Other times it's a guaranteed opportunity to present the appeal to the board in a hearing. One thing that I want to clarify about what that hearing before the board is and what it is not. What the hearing is it's an opportunity for the complainant to share his or her concerns and position on the situation and on the investigation. Then it is also the opportunity of the district, the investigator usually, whoever that was, to share what was found in the investigation and how it went about finding that information. And then the board would deliberate and make a decision. What the hearing is not is, even though it's called a hearing, except in very limited circumstances related to employee discipline, it's not an opportunity for the parties to call and examine witnesses. It's not an opportunity for the complainant typically to ask the district investigator, well, what about this and what about that? It's really an opportunity to just present the sides of the dispute. The examination of evidence occurs at the investigation stage by the investigator, whether that's a district employee or a third person. And so the board members, as the judges, if you will, have the opportunity to ask questions of the complainant, as well as the district administrators or the investigators, whoever did the investigation. But it's not that civil criminal initial trial court examination of evidence that you see on Law and Order kind of thing. It's an appellate process where ultimately the board is deciding, is there a basis for the decision that was rendered based on the investigation, or is there something that's missing, or something that was done inappropriately in the investigation? So wanted to bring that to your attention, that it's not like you're going to be parading witness after witness into closed session. And I don't know actually how many opportunities the board has had to have those investigation complaint appeal hearings. And now I'm going to pause because I'm not 100% sure that you're still there, because we just lost visual of the boardroom. I feel like I'm in like Houston Mission Control.
We're here. Can you hear us?
We can hear you. Yeah, I can hear you.
Oh, our video went off.
Let's see.
Okay, there we go. You're back.
All
right.
We're not doing much, so.
Okay, well, that's good. Hey, everybody's still awake, it looks like. That's good. That's good. So the last thing that we wanted to talk about here really briefly is, well, then what do we do? Carrie, thanks for all this great information, but what if somebody comes up to us on the street like this and is like, hey, Laura Lee, you have to know that this is happening at my kid's school. What should Laura Lee do, right? Because she doesn't want to compromise her ability to sit in a complaint hearing. She wants to be fair to both parties. She wants to be fair to all of her fellow board members. So what should she do? So the best thing that a board member can do is, one, don't blow off the person that is confronting or is confiding in you. I think that, I'm not encouraging you to just cut the person off and send them on their way. That's not the takeaway here. Rather, I think the best thing to do is to listen to them and say, you know what, I hear that you have a concern about X, Y, Z. The board has voted on and passed and created complaint procedures that are specifically for this purpose. And so I really encourage you to go and talk to person X about your complaint. And that person, I think, is best to either be the school site principal, Carmi, or to Jen as the superintendent. And it depends on what the concern is, right? And so I think that you can never go wrong with referring them to Jen, so that then she can identify who the appropriate person is. But I think that the best thing is to refer them to staff first, after recognizing that they have brought this very important concern, at least important to them, concern to your attention. The next thing that I think is appropriate to do, step 2, is to tell Jen about the concern that has been brought to your attention, because we can certainly guarantee that not every single person that comes to you as a board member is actually going to then go and follow your advice to contact someone at the district about their concern. And the reason that I recommend that you go to Jen still about the concern is because some of the things that we have complaint procedures about don't require a formal complaint to be written complaint to be filed before our obligation to investigate them arises. And so if a board member is, for instance, if a board member is aware that somebody believes that they are being sexually harassed at work, that's something that the board member needs to refer to the superintendent for investigation, so that we can satisfy our obligations under the law to find out if it's happening. If it is, take appropriate measures to make it stop. It's also important to make sure that if it is a manager who is engaging in the harassing behavior, that we know about it, because that liability is going to be imputed to the district. And if a board member doesn't take action, then we could already be failing to comply with our complaint procedures before they even start. So again, I think recognizing the concern or the complaint, referring them to the district office or to a principal if that's appropriate, to help them address their concern, and then notifying Jennifer at the district office of the concern, so that a decision can be made about next steps. And I think that by doing that, you're going to ensure that you have kept your division of roles, your separation of powers clearly defined, and you're going to be able to then, if necessary, sit as that final determiner if that complaint procedure comes your way. All right, any questions about that, or actually any questions in general about what we've talked about thus far, before we take a short break to stretch, grab some water, before we come back for collective bargaining conversations? All right, well then, Jen, I don't know how do you want to handle that?
I was gonna set a timer.
Okay.
If I run out of time, you feel, I mean, I think at least 5 minutes, so that we can go to other rooms to get water if we need to use the restroom.
I think that makes
Does that
sense.
sound like a good enough time?
Do you
Okay,
just want to come back at 6:30?
perfect.
All right, we'll see you all soon. Oh, look, we're panning. The camera's panning. I see more people. All right, we'll see everybody in about 5 minutes.
Hello, this is Debbie Myers. I just wanted to say I'm here. This is Debbie Myers. I just wanted to say I'm here.
Hey, Debbie, when did you log
Can you
in?
hear me? Yes.
When did you log in, Debbie?
I logged in, I think I was about 6. 15
Okay.
minutes till 6.
Okay, thank you.
Thanks, Carmen.
You're welcome. I'm sorry.